Regular probate. A majority of probates are administered in long form, and they take several months and even years if, again, the parties are not agreeing, the families don't agree. The attorneys will first determine if there is a last will, a pour-over will, or no last will at all. If the decedent died without a last will, this is called dying intestate. The lawyer will draft an initial petition for probate, just like in the summary. If the client agrees with the wording, then the law firm will have them sign the petition and will file that petition for probate with the court clerk. The court will order that the petition be heard at some future date, usually at least 30 days in the future. Probate lawyers will publish notice of the hearing in the local newspaper and will mail a copy of the notice of hearing to all interested parties. This is usually done by certified mail so we can prove that they got it. At the initial hearing, the court will usually make 4 determinations at that first hearing. Number 1, does the district court have jurisdiction to hear that matter? If the decedent did not live in or have assets in that county, then the court might not have jurisdiction. Number 2, is there a valid last will and testament, and should it be admitted into the probate? Number 3, who should be the personal representative of the estate? They'll actually determine that. This is sometimes called the executor and is usually the person who hired the probate attorneys to file the petition. Number 4, who are the legal heirs, sometimes called beneficiaries, of the estate? Once the court has made those 4 determinations, it will appoint the petitioner as the personal representative. This person is charged with administering the estate of the decedent. This involves gathering and identifying all assets, settling claims, administering the estate, and finally distributing what is left to all of the heirs. Creditors usually have 60 days from the filing of the notice to creditors to file a claim against the estate. Depends from state to state. The notice to creditors is published in a local newspaper in the county where the probate is being administered. Notice to creditors is also mailed to all known creditors of the decedent, again, usually by certified mail. If a creditor files a claim against the estate, then the personal representative decides if it is valid and should it be paid. That claim then must be approved by the court before any payment can be made. A general inventory is usually required to list all of the estate's assets. This list usually includes what is in the estate: personal property, mineral interests, real estate, financial accounts. When real estate or personal property needs to be sold to satisfy debts or to make money available for distribution, the personal representative will make an application to the court for authority to sell real estate or dispose and sell personal property. Again, the judge must approve it. Earlier, I stated that the court determines the legal heirs of the estate at the first hearing, at that initial hearing on the petition. Because the judge has made that determination, all the beneficiaries must agree in writing to sell real estate or personal items by the personal representative. They have to give the personal representative permission. If they do, then the executor usually sells the house with a realtor and deposits the proceeds into the estate bank account. This is a separate bank account. Once the personal representative has gathered all of the assets, paid and settled all claims, then and only then is the estate ready for closing. This is usually done by a final account. You guessed it, another pleading. Notice of that hearing for final account is published in the newspaper, mailed to all interested parties, again by certified mail, and usually set for some future date, 30 days into the future, again depending on the court's schedule. As you can see, if everything goes perfect, a probate will take 4 to 5 months. They never go perfect, and they usually last 5 to 7 months. If the family starts fighting, then it might take even years to complete a probate. We have had that happen on a regular basis where the family just can't get along, and it just takes years because it's hard to get onto a judge's schedule. So the best thing that you can do is to get along with your family. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.